Hi, my name is Shawn.hamp. I want to welcome you to my slideshow presentation. This is part of the Arizona Legal Systems Education Series. This presentation is entitled, What is a Misdemeanor Change of Plea Hearing? So first of all, a little bit about myself. Again, my name is Shawn.hamp. I am a trial attorney here in Mojave County, Arizona. I'm the president of the law offices of Shawn B. Hamp. We practice criminal law in our office. I'm a former deputy county attorney, formerly worked with the Mojave County Attorney's Office. I am a member of the National Association of Criminal Defense Attorneys. I'm also a member of the Criminal Justice Section for the State Bar of Arizona. Now, we're talking about misdemeanor change of pleas hearing, and I primarily want to focus on change of plea hearings in Mojave County. Most courts in Arizona are very similar, very much the same. They all do have their own courts, local rules of procedure, local things of doing things. So, primarily, I'm going to be speaking about Mojave County limited jurisdiction courts. So, in Mojave County, as you can see, we're in northwestern Arizona. There are six limited jurisdiction courts in Mojave County. They include the Kingman Cerbat Justice Court, the Kingman Municipal Court, the Bullhead City Justice Court, the Bullhead City Municipal Court, the Lake Havasu City Consolidated Court, and the North Canyon Justice Court. These are all courts of limited jurisdiction. So when we say it's a court of limited jurisdiction, that means that they can only preside over small claim civil cases, and when it comes to criminal cases, they can only preside over misdemeanor cases. Now, some felony cases do start in the Justice Court, um, but they have a very limited role in those felony cases. So, misdemeanors are handled in limited jurisdiction courts. Now, what is the purpose of a change of plea? Well, when a defendant makes an initial appearance, they usually plead or should plead not guilty at the arraignment, and then the court sets the matter for a pretrial conference. At the pretrial conference, police reports and disclosures given to the defendant, and usually the state will offer a plea offer. So when the defendant is given a plea offer, they have to make a decision. Are they going to take the case to trial, or are they going to take a plea agreement? And if they decide to take a plea agreement, then the court has to set a hearing. They have to set a change of plea hearing. And at the change of plea hearing, that is when the defendant states on the record that they will accept the state's plea offer. And then they'll change their plea from not guilty to guilty. So let me show you an example of what we're talking about. I've had a little simple flow chart here. Um, it shows you that when you get arrested for a crime or you get summons to appear in justice court, you will have an initial appearance conducted. And again, like I said earlier, the initial appearance or arraignment in the justice court or municipal court, that is when a defendant is told what they're charged with, and that's when they enter a not guilty plea. Then the case is set for a pretrial conference. And like I stated previously, that is usually the time when the defendant is given the plea agreement, the plea offer. They're given copies of the police reports, and then they have to decide, are they going to set the matter for a trial, or are they going to set it for a change of plea? So, like we're talking today about change of plea, so that's when the defendant will set their change of plea hearing. So we'll talk about the order of proceedings. Here's some more examples of the local courts here in Mojave County. There's a picture of the Bullhead City Municipal Court, the Kingman Cerbat Justice Court, and that's a picture of the courtroom inside the North Canyon Justice Court. So let's talk about the order of proceedings. So under Rule 17.2 of the Arizona Rules of Criminal Procedure, a judge has to go through a certain number of steps to conduct the change of plea hearing. The rule clearly states that before accepting a plea of guilty or no contest, the court has to address the defendant personally in open court and has to inform him or her and determine that he or she understands the following. So the first thing that the judge has to do is make sure that the defendant understands the nature of the charges that they're charged with. Then the judge has to explain the range and consequences of the sentence. I would note that for a Class 1 misdemeanor, that would include up to 6 months in jail or a $2,500 fine. The judge then has to advise the defendant of what constitutional rights they're giving up by taking a plea and giving up their not guilty plea. The judge has to explain to the defendant that they have a right to plead not guilty and that they have a right to be presumed innocent until proven guilty. And by taking the change of plea, they're going to be giving up that right. The judge also must explain to the defendant by taking the plea that they're going to give up a right to direct appeal. And the judge also has to explain the immigration consequences. So this is Rule 17.2 of the Arizona Rules of Criminal Procedure. This requirement is required in all cases, whether they're misdemeanors or felonies. So the same thing applies in felony cases as well. The judge, like I stated previously, has to advise the defendant of the nature of the charges and the possible sentences. So a Class 1 misdemeanor, which most defendants get charged with Class 1 misdemeanors. It's the most serious misdemeanor class of misdemeanor you can be charged with. And that, like I said previously, it's up to 6 months in jail, up to a $2,500 fine. So Class 1 misdemeanors would include offenses like DUI, domestic violence, disorderly conduct, assaults with an injury. Those are Class 1 misdemeanors. Class 2 misdemeanor, that sentence range is up to 4 months in jail or a $750 fine. And a Class 3 misdemeanor is up to 30 days jail, $500 fine. So with the Class 2, Class 3 misdemeanor, for example, a Class 2 misdemeanor assault would not involve an injury, be not as serious as an assault involving an injury. Usually it's just threatening someone to do harm to them. That would be a Class 2 misdemeanor. A Class 3 misdemeanor, for example, might be as a criminal speeding charge, would be a Class 3 misdemeanor. So you can see that there's, even though misdemeanor doesn't involve prison time, just maybe it might involve some jail time, there are different classes of misdemeanors, and they all have their own unique sentencing range. Now, the judge also has to advise the defendant of their constitutional rights. And these constitutional rights include the right to an attorney, the right to remain silent, the right to a trial, the right to be presumed innocent, the right to cross-examine witnesses, the right to call witnesses on their own behalf. And then the judge has to determine that the defendant is going to give up these rights voluntarily. So the judge does that by making sure that the defendant knows what their rights are, and then the judge would ask them, has anyone threatened you or made promises to you other than what's in the plea agreement to make you change your plea from not guilty to guilty? So part of the proceedings, the judge is addressing the defendant personally. They're not talking through the attorney, they're talking to the defendant straightforward. And the judge has to make sure that the defendant knows what rights they're giving up and make sure they understand it and make sure that they're not being coerced to do it or they're given bad information to plead guilty. So the judge has to go over all these rights to make sure that the defendant understands them. One of the things that defendants give up when they take a change of plea and a plea agreement is their right to direct appeal. So I tell my clients, this almost verbatim every time, basically tell my clients, By taking the plea agreement, you're giving up your right to a trial. So if you went to trial and you got convicted, you could appeal that case to a higher court. You could appeal it to um, argue if there was any errors during the proceedings. So, some examples of errors, there might be some evidentiary issues that the judge ruled against you. There might have been some motions to suppress, or some other motions that the judge denied, but there was a legal basis to grant those motions. So those are the types of issues that you could appeal. When you take a plea agreement, you're basically telling the judge, this is how I want to resolve my case. And I understand that I'm giving up my right to appeal because I want to resolve my case this way. Now, the judge will explain to the defendant that once you enter the plea agreement, you cannot back out of it. And basically, you can't back out of it unless you have a really good reason. They call that a manifest injustice. So the point of that, though, is that once you enter a plea agreement, it's really hard to get out of that plea unless you have a really good reason. And the judge has to make sure that a defendant understands that they are giving up that right to appeal. And these are some of the constitutional rights, again, that the defendant's giving up. By pleading guilty, the defendant always has a right to an attorney to assist them during the proceedings. If they can't afford an attorney, one's appointed to them. Defendant has a right to remain silent. So when you enter a plea agreement and you admit to the charges, you are giving up that right to remain silent. You're telling the judge, I did it. You're giving up a right to a trial. In Arizona, most misdemeanors involve a right to a bench trial, which is a trial by judge. Some cases you do have a right to a jury trial, such as DUI cases or theft cases. You obviously are giving up your right to be presumed innocent because you're changing your plea from not guilty to guilty. You're giving up your right to cross-examine witnesses that the state will bring to prove your guilt. You also give up the right to call witnesses on your own behalf. So, again, that's one of the key purposes of the change of plea hearing, is to make sure the defendant knows what they're doing. Because once you do a plea agreement, and once you enter a plea agreement, very difficult to get out of it. The court also has to advise the defendant of certain collateral consequences. And one of the consequences of pleading guilty, or collateral consequences, is immigration consequences. So the judge will basically tell the defendant that they have to read this warning to them regardless of their ethnicity. But if by pleading guilty it may affect non-citizens of the United States, it could have immigration consequences. Of course, this doesn't apply to U.S. citizens, but if you weren't a U.S. citizen, your right to become a citizen or your immigration status could be affected. And especially applies to drug crimes. Any drug crime could have a negative impact on your immigration status, and also crimes of moral turpitude. So, just some final points, just to stress to you again. You cannot back out of it, of the plea agreement. I get calls all the time. People enter a plea agreement and they have some second thoughts, and they complain about their attorney not being effective, or the public defender not listening to them, and they felt pressured to enter a plea agreement. And that's why the judge asked all those questions during the hearing. They asked them questions like, if they were threatened, or are they satisfied with the help of their attorney? And the judge has to determine all that. And once the judge has determined all that, determines that the plea is knowingly, intelligently, and voluntarily, judge is going to go ahead and enter that guilty plea on the record. So if you're in this predicament, and if you are going through a misdemeanor criminal case, just keep that in mind that if you do decide to change your plea, um, you'll be stuck with it. You will be obligated to the terms of the plea agreement. A change of plea hearing is a third party agreement. When you enter a change of plea agreement, it's an agreement between you, the prosecutor, and then ultimately the judge, because the judge has to approve the agreement. So always keep that in mind. That's one of the purposes of the change of plea hearing, is so the judge finds out about the case and determines whether it's appropriate. And then the other thing is, in misdemeanor courts, when you do plead guilty at the change of plea hearing, the court will most likely go straight to sentencing and sentence you for that crime. And obviously, if you do a change of plea, the sentencing range will be dictated by that plea agreement. So, I want to thank you very much for watching this video. I want you to know that you can follow us on YouTube and see some of our other videos. You can like us on Facebook or tweet us at Twitter. And if you need to contact me, feel free. I am at the email and website address below. So I hope you enjoyed this presentation and watch our other videos online. Thank you.